release me from my winter hell. I've got candles and candy, I can be your daddy if you only let me creep into your prison cell. Hey baby, can you tell I'm not a criminal? Your choice is seminal. I want you to stay true to what's right for you. No matter who or know what will others say, just find your way and try to stay true. Speak low, stand in your row, try not to show this life's a show. Try not to glow way down below. Oh, it's a lot of woe, and that's not a place where you would like to go. I've got cigarettes and brandy, which could come in handy if you just help me loosen up my hand grenades fuse. Baby, don't refuse my truth, but it's up to you now to choose. I want you to stay true to what's right for you. No matter who or know what will others say, just find your way and try to stay true. I want you to stay true to what's right for you. No matter who or know what will others say, just find your way and try to stay true, 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 true,
Good morning, you guys. Give me just a okay. That's better. I needed to move my mic, but if you move it while you're live and it's unmuted, it makes a noise, and I don't like to do that to you guys. Good morning, everyone. How are you? I hope everybody is doing well. Now, let's just tell you what's going on today. So right now, what we're going to be watching is what's called the charging conference. It's basically jury instructions. Okay. We'll also find out how much time Judge Bev is going to allow the sides to have for closing arguments. Now, Mr. Jackson last night, wanted 2 hours. Judge Bev was like, nah, bro, you ain't getting 2 hours. And so he compromised and wanted maybe an hour and 15 minutes. And she said, I'll think about it. So we'll see. Good morning to everybody. Let me say hi to you guys, and then we'll talk a little more. Good morning, Rachel. Good to see you. Good morning, Sarah. Good morning, Mrs. Troy. Good morning, Shamita. Good morning, Seven Lilies. Good morning. It's about time. And thank you very much. I'm glad that you like my my intro. Yeah, it's about time, since I'm trying to make an intro and I understand the effort and smart it takes. This is so good. Thank you. I'm not going to go so far as smarts. I believe you guys have seen my smarts, and it is sometimey at best. But it does take time. It does take time. but I have every faith and every confidence that you can do it. Boho hobo, I promise. Good morning, Kelly Renee. Good to see you. Good morning, Sissy's mom, Jen. It's good to see you. Good morning, non-blonde millennial. Good morning, Julie A. Good to see you. Good morning, Groshang Bammy. Good morning. It's good to see you. Good to see you. And good morning, Brandy. Good morning, Neat Noodle. Good morning, Tosh. Good morning, Jay. Rose. Good to see you guys. Thank you so much for being here. I hope everybody had a great night last night. Now, currently in Arizona, okay, the jury is out. They're not deliberating at all. Okay. Court isn't in session. They get there at 10. So that's 12 Central, 1 Eastern. So they're not even, it's only 7 o'clock there. So nothing's going on as far as the jury deliberating. But once they do begin deliberations, of course, I will have on another screen the verdict watch. So just in case, if we're in the middle of this and there's a verdict, we'll go right there because, I can't wait for all of this to be over with Lori. I think that she needs to fade into obscurity and that be the end of it, frankly. That's how I feel. So that's just my opinion. Now, I hope Arizona is not done with the co-conspirators, aka Melanie Boudreaux Pawlowski. Girl.
Hey, thanks so much for watching the Karen Reed trial with us, but I wanted to tell you guys about something real quick.
Thanks, Jesse. Well, you can tell us real quick on mute. I can't. Anyway, Melanie, you in trouble, girl. And it's about damn time. That's all I got to say. I forgot what I was going to tell you guys. Oh, good morning, Wally. Handsome guy. Let me know. Hey, S. Hockett. Good morning. Good to see you. Good morning, Violet. Good to see you too, babe. How you doing? How's everybody? I hope everybody's doing well. So, okay, normally I watch the charging conference, the jury instructions. I watch those privately because it's very dry. It's usually, but in this situation, in this case, okay, because the jurors had such trouble with their instructions, the verdict forms, etc., I am so curious as to how I don't, it's not really about Hank. Hank is going to be Hank. Okay. Which, speaking of, I took the opportunity this morning while I I had the opportunity to sleep in, right? And I was so excited about that. I'm going to sleep in. Y'all know I woke up right on time, 6 o'clock. I didn't oversleep. I didn't snooze my, sleep through my alarm. None of that. Okay. As every other day I have when I'm supposed to be live at 7:55. So thanks, brain. Anyway, so I am making a video about the trial, just some things, and so there's that. Good morning, Tess. Good to see you, babe. I will be looking out for that. But anyway, normally I don't usually stream the charging conferences just because I just don't. I just usually watch it by myself. That way I can, if something comes up, I understand what's going on, right? But like I said, because there was such an issue this last time during the last trial, I thought we should watch and see how it all goes down. Now, again, I expect Hank to Hank. Period. That's it. That's all. He's not going to be. We've all seen his demeanor. We all are familiar with his brand. It is what it is. What I am curious about is the defense, because I was watching Duty Ron last night, and that was a really good live. Him and Ed are funny. I have to give Duty Ron props for his soundboard, because he's got a clip from Ferris Bueller's Day Off where Cameron says, "Pardon my French, sir, but you are an asshole." And it's hilarious to me. But he also has my favorite, and I say this all the time to in my real life. He has Fast Times at Ridgemont High, Spicoli, when Mr. Hand tore up his schedule, and Jeff Spicoli goes, "You dick." It's my favorite. I love it. And he played that last night, and he played it at the right time. It was great. It was great. It was it was an informative live, but I was watching it last night, and he played a clip of Karen Reed after court yesterday. And, she talked about how she was part of jury selection process. She spoke about how the verdict forms and instructions were unclear, what happened last year with that, and how they're going to have to pay much closer attention and really just that. But I also want everybody to remember that they have a juror on their team who was a juror for the last trial. And I believe that her services and her input, particularly at this juncture, is key. So, and I know that they value her opinion. I know that they value her input. And so here comes Judge Beth. Look at Judge Beth.
Was now open. You may be seated.
Good morning, Your Honor. May I call the case?
Please.
For the record, before the court is Commonwealth.
Yeah. Look at Judge Bev trying to act like she did some work. Judge Bev, you left that crap at the office while you were out karaokeing last night, singing Journey. Give me a break.
Good morning, Ms. McLaughlin.
Adam Malik from Commonwealth. Morning, Your Honor.
Good morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan for the Commonwealth.
Morning, Mr. Brennan.
Morning, Your Honor. Robert Alessi from Ms. Reed.
Good morning, Mr. Alessi.
Good morning, Your Honor. David Yannetti from Karen Reed.
Good morning, Mr. Yannetti, and good morning, Ms. Reed. All right, so Mr. Yannetti and Mr. Alessi, you're standing in also for Mr. Jackson and Ms. Little?
We are.
Okay. All right, so first thing we left off yesterday was whether KKKK for identification, the PowerPoint of Dr. Rentschler would be entered into evidence.
Before we get to that, I want to answer Tess, because I do have many thoughts. So Tess says, there has been some very interesting conversations about the reasoning behind Hank deciding not to call any rebuttal witnesses. Any thoughts from your perspective? Many. I'm going to start with first and foremost, okay? Hank had, I think, initially intended to call the crime lab technician, who is the one who actually did the cuttings on the hoodie. And he can't call her for obvious reasons, in my opinion. One, after what happened at the, with Dr. Wolf, when he was talking to Dr. Wolf about the hoodie and trying to imply in some way that Dr. Wolf didn't do a thorough investigation of all of the available evidence, as if those defects came from something happening on January 29th, 2022, when in fact the reason why there were holes in the first place on the back of that hoodie is because there were cutting samples taken at the crime lab. Okay. He can't call her. Okay. And here's why. Because if he calls her on rebuttal, right, the defense can ask, When did you make your report respective to the hoodie? When was that report turned over to the Commonwealth? And right there and then, once the jury hears that, they got common sense. They're going to put 2 and 2 together. They're going to get 4, and they're going to realize that Hank Brennan tried to hoodwink them, bamboozle them, led them astray, all the things, right? So he can't call her. All right. Now, Dr. Welcher. He can't call Dr. Welcher because yesterday was an absolute freaking debacle. That was the most backfire of a cross-examination I've ever seen in my life. And that's saying some things, because I've seen some things in some trials. Okay. Can't call Dr. Welcher for many reasons. All right. Dr. Welcher testified in the Commonwealth case in chief that there, quote, were no x-rays. Okay. Well, we know there were x-rays. And so that opens the door to, if you had seen those x-rays, oh, and by the way, here they are, would that change your opinion? That can be problematic. And it can be, the knife cuts both ways. Okay. It can be problematic in that he could say no. That would be problematic for the defense. But if he says, well, yeah, I would have liked to have seen those. They would have mattered in my evaluation. I like to see all of the medical records, right? That's problematic for the Commonwealth, because the jury's going to be like, well, why didn't they show them to Dr. Welcher, right? So I think the reason that Hank Brennan, bottom line, end of point blank period, he cannot call the rebuttal. He can't put on a rebuttal case because, quite frankly, it doesn't matter how many rebuttal witnesses he calls. At the end of the day, I believe that the jury will find that there is far more weight and credibility in the testimony offered by the defense witnesses, who concluded that there was no collision, that John O'Keefe's injuries and subsequent death are not the result of being hit by a vehicle, any vehicle. And so it would be basically a waste of time. And quite frankly, it could go even worse, if that's even possible, which I think it is possible. So that is why I think that's why he chose not to. It was, as to put it in Hank Brennan's terms, strategic. He's so whiny. Let me try it again, because he kind of talks like this. It was strategic, yeah, like that. He's kind of got like a nasally thing. So I also want to correct something really quickly too, just for you guys. That the defense has not rested. Okay, the defense must rest in front of the jury. And the reason that they have not rested yet, which they could have rested yesterday, they chose not to. And the reason they chose not to is because they want that PowerPoint presentation to come in as evidence, even though, over the objection of the Commonwealth. All right. So I'm going to rewind a few seconds so we can get to hear Judge Bev's ruling, because that's what she's going to rule on. All right. Let's get it on.
KKK for identification. The PowerPoint of Dr. Rentschler would be entered into evidence. It will not be based on the objection, so it is excluded from evidence. So it's marked still for identification, and your rights are saved on that.
Why, Judge Bev? What is the legal basis for your ruling? Why don't you at this point, I think it would behoove you, and I also think it's incumbent upon you to explain to the defense why it's not coming in at all. There's no compromise there. Like, it can't, if slides, whatever the issue is, come out, can it come in? At this point, I'm not surprised that Bev decided this way. This is just very on brand for Judge Bev because I said so. All right, that's it. That's all. She just runs. That's just her brand. But I don't think honestly that it's going to be detrimental in the jury's deliberations. I do think, based on people that were in the jury or were in the courtroom yesterday, that watched the jury, that report on X Twitters what the jury is doing. And thank you to Tess Mack, who always brings that, puts it in the chat, what the jury is doing. I think they were paying very, very close attention particularly at key moments during both direct and cross-examination of Dr. Rentschler. And so I think that's not going to be a hindrance, although by judging by Judge Bev's ruling, I think she does think it's going to impact the deliberations. And I think she thinks that if they had it, it would help them come to a not guilty verdict. That's just my opinion, and I'm allowed to have that. So that's what I think. Let's keep going.
So we ready to go forward with the charge conference?
Sure.
Yes, Your Honor. I guess I have a question first as to whether the court would like to entertain the argument on the motion for required finding not guilty of all the evidence.
So, no, we can do that now. So now that my ruling is on this, evidence is closed. Evidence is closed as it was yesterday. So go ahead on your required finding argument. Sure.
And this is not lengthy, Judge, 5 or 10 minutes.
Take your time.
Thank you. We are renewing our motion for required finding of not guilty at the close of all the evidence, and in so doing, Your Honor, we're incorporating our oral argument in support of this motion that we made at the close of the Commonwealth case. At that juncture, Your Honor, the Commonwealth had produced no witnesses to testify that John O'Keefe's injuries were consistent with his having been hit by a motor vehicle, and if he was not hit by a motor vehicle, none of these three indictments may stand. The Commonwealth, we believe, at that time fell woefully short of proving their case. Now that the defense has put on a case, the Commonwealth's case has been further weakened, such that none of these charges can stand. Nearly every witness, Your Honor, we have called, we would submit, has destroyed the Commonwealth's theory of the case. Dr. Russell testified for the defense. She's a leading expert on dog bite wound pattern recognition in the country, and she testified about medical injury causation and provided the jury with her expert opinion that John O'Keefe's injuries were consistent with dog-inflicted wounds, both bites and scratches. I would remind the court at this juncture that there was a dog at the very residence where John O'Keefe was found, a dog which was a longtime member of the family, which the family gave away after John O'Keefe's death. A dog which mysteriously was absent from the home at 6:30 in the morning on January 29th, when Jennifer McCabe claimed that she burst into Brian Albert's bedroom where the dog always slept. A dog which was absent from the home when the Canton police entered the home later that morning. Importantly, Dr. Russell agreed with the Commonwealth's medical examiner, Dr. Scorty Bello, that John O'Keefe suffered no injuries that were consistent with having been in a motor vehicle collision. And
so Tess asks, this is something they always do, correct? Yes. At the end of the trial, when all of the evidence has been admitted, right? As admitted into evidence, right? All the exhibits and whatnot. They always move for a judgment of acquittal, directed verdict. They call it different things, but yes, this always happens. This is par for the course. I want to say good morning really quickly. Hey, Tony, good to see you. I hope your move is going well. We have certainly missed you, of course. I noticed your absence and I missed you, and I was wondering about you and hoping that everything was going good with you. So let me rewind it a few seconds because, this is important. I think we all know how Judge Bev is going to rule, but let's just, at least she's entertaining this and telling him to take his time for whatever reason. All right, here we go.
Russell agreed with the Commonwealth's medical examiner, Dr. Scorty Bello, that John O'Keefe suffered no injuries that were consistent with having been in a motor vehicle collision. And again, if there's no collision, there's no case. Dr. Lopesada, one of the most experienced and accomplished forensic pathologists you could find anywhere, agreed with Dr. Russell that John O'Keefe's injuries were consistent with an animal attack. And she agreed with both Dr. Russell and the Commonwealth's expert, Dr. Scorti-Bello, that John O'Keefe was not hit by a motor vehicle. So the question is, in what type of murder case would a judge ever allow a motion for required finding of not guilty? In a murder case where expert testimony on both sides is that the evidence is inconsistent completely with the Commonwealth's theory of the case, that's exactly what we have here. But it doesn't stop there. Both witnesses from ARCA drove a stake through the heart of the Commonwealth's case. Dr. Wolf concluded that the damage to Ms. Reed's Lexus was inconsistent with having come from a collision with John O'Keefe. Unlike Dr. Welcher, who created, we would submit, a meaningless experiment based on no scientific method, Dr. Welcher actually did the proper force analysis and concluded that Ms. Reed's Lexus was not damaged by the body or the arm of John O'Keefe. His testimony was unimpacted by cross-examination, and it's devastating to the Commonwealth's case. Dr. Rentschler further cemented that there was no collision between the Lexus and John O'Keefe. It is simply not possible that this 6,000-pound SUV hit John O'Keefe at 24 miles an hour and caused only superficial wounds to his right arm with no injuries to his legs or lower body. The SUV did not hit him. John O'Keefe was not hit by the SUV. The case is over. But on top of all that scientific evidence, Your Honor, there were 3 additional fact witnesses who testified for the defense who corroborated that the Commonwealth's theory of the case is false. Sergeant Nicholas Barros, a sworn police officer, testified that when he saw Ms. Reed's SUV that day, before it was towed to the Canton Police Sally Port, the taillight was merely cracked. When he was shown photos of what it looked like in the Sally Port after Michael Proctor had access to it, Sergeant Barros confirmed that it was absolutely different. Karina Kolakithis confirmed that there were no problems between Karen and John O'Keefe that night, even remarking on just how sweet he kissed her on the forehead shortly before they left the waterfall. But perhaps more importantly, that kiss happened right in front of Brian Higgins, the same Brian Higgins who had been flirting with Karen Reed that month, the same Brian Higgins whom Karen had ghosted for several days before January 28th, the same Brian Higgins who had texted Karen that very night, well, and received no response, the same Brian Higgins whom Karen had given her back to all night, the same Brian Higgins who had to be restrained at the end of the night by Chris Albert on video, the same Brian Albert who is on video, hot, angry.
Brian Higgins. You just said Albert. You mean Higgins, right?
I meant Higgins, yes. Yeah, the same Brian Higgins, who is on video, hot, angry, and gesturing to John O'Keefe to meet him outside shortly before they left the waterfall and shortly before John O'Keefe was killed. And finally, Brian Loughran, plowing Fairview Road at 2:45 in the morning, was attentive, watching everything in front of him, very familiar with the Albert's residence, and had every reason to protect the Albert family. You recall that he did protect the Albert family to a degree that night by choosing not to follow protocol and call the DPW or the police about the Ford Edge parked on the street outside their property during a snow emergency. Brian Loughran confirmed that John O'Keefe was not on the front lawn at the Albert residence at 2:45 a.m. That means that Karen did not hit him. There was no collision. All the experts agree on that, including the Commonwealth's expert, and the only eyewitness that morning confirms it. Taking the evidence in the light most favorable to the Commonwealth at this juncture, with their evidence weakened by an airtight defense to these charges, these indictments cannot stand, and we urge this court to enter required findings of not guilty on all 3 indictments.
All right, thank you.
Thank you, Your Honor. Commonwealth requests that the defendant's motion for required finding not guilty at this juncture, as it was at the close of the Commonwealth's case, be denied. The state of the evidence is not dramatically changed since the Commonwealth rested its case in chief. Counsel makes reference to dog or canine. I would remind the court that there is absolutely no evidence, none, not even a scintilla of evidence of a dog. There is no evidence of an absence of a dog. You have Ms. McCabe testifying that she didn't see it in the morning, which does not equate to there being an absence of a dog there. The arguments from counsel of the Commonwealth would suggest grossly exaggerates the strength of the defense witnesses in their case. The bias and advocacy exhibited by those witnesses from that witness stand do not amount to credible witness testimony that undermine the Commonwealth's case in any way, shape, or form. A couple of specific examples. When it came to Officer Barros, his testimony was also that the cruiser camera footage from 8:22 in the morning at the driveway at One Meadows Ave, he indicated the damage to the taillight was consistent with the damage that he observed in the driveway at the defendant's parents' home, which was then consistent from the video or the photographs within the Sally Port. It's also consistent with 5:07 a.m. at One Meadows Ave on the still frame shots from that ring camera video. Essentially, the Commonwealth would submit that the defense witnesses all conflict with each other. You have a couple witnesses testifying about dog or animal bites. Then you have the ARCA witnesses testifying about superficial abrasions. You have Dr. LaPosada talking about the drop in body temperature, which conflicts with Mr. Loughran's testimony as far as his confusion, as far as the hours of when he sees or claims to have driven by there and not seen a body. This is the same witness who is, I would submit, very confused on times, and then also backed into a basketball hoop during the course of his plow duties on that particular early morning as well. And as the court could see from the cruiser camera video, drove by the scene countless times, essentially rubbernecking it as he's going past doing his duties. Your Honor, what the Commonwealth would submit is that his case was more than sufficiently strong at the close of the evidence in his case in chief. There has been nothing presented in the defendant's case to diminish, particularly to the standard in the light most favorable to the Commonwealth, and we request that the defendant's motion be denied.
Okay, so Crocheting Bammy says, why do they do jury instructions before closing? I would think that is the last thing they should tell the jury before deliberations. Do I have that wrong? Well, no, you don't have it wrong. It depends on the judge. Some judges split the jury instructions. So they read like half of the jury instructions, then they allow the state and the defense to do their closing and then rebuttal closing, if there is any. And then they read the last half of the jury instructions. And I think that the thinking in that, doing it that way, is because even though, yes, the other day when you guys were asking about jury instructions, I kind of misunderstood what you guys were asking me, but I understand it now. So, and we heard it yesterday during Lori Vallow's trial, during the closing arguments. What both sides will go over the charges, okay, and kind of what the jury needs to find the person, depending on who's arguing, right, guilty or not guilty of those charges, and then they apply the evidence to those instructions and all of that. So I think that it just depends on the judge, and it's up to them how they do the instructions. Some judges, like I said, they do all of the instructions and then the closing arguments, because the other thing about that is the jury gets a copy. Each juror gets a copy of the jury instructions to go back with them through deliberations. And I think that the thinking is that this is basically the last time the jury is going to hear from the attorneys, and that's why they do it that way. But like I said, it's just up to the judge's discretion. All right, so let's Judge Bev is going to deny it, so let's keep going.
that way, the Commonwealth has met its burden, so the motion's denied.
I mean, are we surprised? In viewing it under in viewing it with the light most favorable to the state, okay? Even if you give them all the favorable light, all right? And it's even a higher bar, the bar for most favorable is set even higher. The Commonwealth didn't prove their case. They didn't meet their burden. Their own medical examiner, not medical, well, their own forensic pathologist who performed the autopsy on John O'Keefe, no matter what pressure she was given, never backed off of her original findings. Because if she thought that this was due to that John O'Keefe died as a result of being hit by a vehicle, she would have ruled it a homicide. And let me tell you why. Because homicide, when it comes to the forensic pathologist, the medical examiners, their what's the word I'm looking for? Definition of homicide is very different than the legal definition of homicide. Homicide, when it's ruled that way from a medical examiner's standpoint, is simply the taking of a life by another human being, one human losing their life at the hands of another human being. Homicide and murder, as it's charged from from a prosecuting standpoint, that definition is different. Okay, and so if she thought that his death had come at the hand from a vehicle, she would have ruled it homicide, but she didn't.
Okay. All right, so regarding the charge, so we'll start with the defendant's missing witness request. Who's arguing that motion?
We're not arguing that, Your Honor. And I apologize, but we made the decision last night to withdraw 2 of our requested instructions, which would shorten things today, I think.
Oh, okay, so everything on this is done, right? The defendant's motion to present a missing witness argument and request for instruction, you're withdrawing that?
With regard to the absent witness instruction, we're withdrawing that request.
Okay. And what else from your proposed instructions? You said there were 2. What's the second one?
The second one is that there's an entry on our request for lost or destroyed evidence. We're withdrawing that request.
Okay, I had a question about that. All right, thank you.
There is a supplemental instruction that we're asking the court to give regarding the display of the sweatshirt.
Oh, that's right, you filed, I saw it in email. I don't have a hard copy of it.
That's Mr. Alessi's motion.
Your Honor, if it's helpful to Your Honor, I'll hand up my hard copy.
Okay, if you could do that, I'd like to go back through the rest of it and come back to that after I've read it, okay? Who's arguing for the rest of the defendant's proposed instructions?
I am, Your Honor.
Okay, so we're going to go through them one at a time. Who's arguing for the Commonwealth? Okay, so I think you're sort of in agreement on the basis of the law, right?
Yes.
All right, so model homicide instructions, and just as last time. So that takes a lot of time out of today.
The only thing I would draw the court's attention, the Commonwealth does have a request for, and I understand the court's position might be on this, but as far as the instruction relating to murder charge, the Commonwealth is only seeking an instruction on third prong.
All right, so we will deal with that. I'm going to go through the defendant's instructions are sort of the general instructions first, so it's probably easier to go through those, and then we'll have the argument on that. So presumption of innocence, I think my presumption of innocence is a little more robust than what you've requested, so I will probably, okay. And I will give some version. I know that there was a lot of attention paid and some appellate decisions on the each individual indictment. I'll give some further language on that. You've got an instruction proposed on page 4, reaching a verdict. Just, I will make it crystal clear, though I think it was, and I was upheld on it, so I will make it crystal clear. Okay? So I'll give you that, Ms. Gianetti. is what is evidence. I probably won't give verbatim what you have. I'll take a look at it, but I will certainly cover all these topics. So, Ms. Giannetti, you're telling me that your client wants me to give a defendant did not testify instruction?
Yes, please, Your Honor.
Again, if you want to take a look at what I gave last year, I think it's a little more robust than this.
I think we answered satisfied with the court's instructions on that, so we would be satisfied again with the court's language.
Okay. Humane practice, I will give you Bowden. I'm going to take a look, size this up with what I gave last year. I gave Bowden last year. I gave a Bowden instruction. I don't think the Commonwealth objects, right?
We would object to the instruction.
Okay. Go ahead. Do you want to make an argument?
Just briefly, Your Honor, when it comes to the Bowden, and I would incorporate, and I know there's no request for instruction for third-party culprit, but the Commonwealth would be making a similar request that counsel be prohibited from making a third-party culprit or Bowden argument.
Or Bowden? Or Bowden?
I'm sorry?
You don't think the Commonwealth, the defense should be allowed to make a Bowden to argue Bowden?
So I would submit, Your Honor, that the entirety of any testimony or evidence related to either Bowden or third-party culprit in this trial has come from questions from the defense counsel, not from actual evidence in the case, not from testimony from witnesses from the stand, exhibits that have been put into evidence, or anything of the like. So in the instruction and the arguments are based or predicated in the case law on evidence, not, and obviously as the court is well aware, there's a specific instruction that no matter how powerful they are, questions to counsel are not evidence. So what the Commonwealth would submit is that the court looks at what is actually in evidence in this case. There is no basis whatsoever for not only a Bowden or third-party culprit instruction, but specifically for even counsel to make that argument during the course of the closing. And I understand Bowden is a little bit more loose as far as the court certainly.
So I'm going to ask Ms. Giannetti to explain to me. All right, so I disagree with you on Bowden, but I'll take a closer look at it. Ms. Giannetti, what is the Bowden evidence that warrants an instruction?
I think it's multifaceted, Your Honor. The police did not secure the crime scene properly. They used inadequate material to pack the evidence. Chain of custody was contaminated and corrupted. There was evidence of the bias of the investigator, failure to pursue other suspects, specifically telling his friends that the homeowner was sacrosanct because he's a Boston cop too. There was just a focus on Ms. Reed to the exclusion of everybody else. It was not an open-ended investigation. From day one, it was focused on one person and one person only. And just responding briefly to Mr. Lowry's comments about how he didn't introduce affirmative evidence of the proper way to do an investigation. We tried, Your Honor, we made a motion and renewed it, asking for reconsideration of the court's ruling that Mike Easter could not testify about in an investigation. So to say that we didn't introduce that evidence when we tried to do it,
I think what Mr. Lally was saying, that you asked questions but weren't given answers, and so I think that's what was said. I'm going to Mr. Yannetti, I'm going to allow you to argue Bowden, and I am going to give an instruction. So third-party culprit's an entirely different animal here. I know, but tell me, are you going to argue it? Is the defense going to argue that Brian Higgins did this?
No, we're going to argue that the police failed to investigate whether Brian Higgins did it.
Okay, so just so that it's clear, you all know, I believe, third-party culprit separately is a lot different than third-party culprit as it goes to Bowden. I ruled pre-trial that there could be no attempt at introducing third-party culprit evidence regarding Colin Albert.
Correct.
So that was separate. But I did say that I would give you the opportunity to try and develop testimony regarding Brian Higgins and Brian Albert as third-party culprits. That threshold that you need to make to do that, to argue them as three-party culprits, has not been made by the defense. So you cannot argue that either Brian Higgins or Brian Albert committed or had the motive and all of that. Not third-party culprit, pure third-party culprit. You understand that? It sounds like you're telling me you don't intend to do that.
We understand the distinction, Your Honor, and we're strictly going with a Bowden defense.
Okay, so you can get into third-party culprit with Brian Higgins, that the police were aware of whatever you're going to argue and failed to act on it. But it's strictly for that purpose, okay? Okay.
Okay, so basically, as I understand it, what Bev is going to allow is what's known as the Bowden defense. The Bowden defense is basically where the defendant argues that the police investigation into this crime was horrible. It was not good. And so, therefore, they should be found not guilty based on that, just because the evidence that the investigation was conducted so poorly that it can't actually point to anybody as as the accused, right? But particularly the actual defendant. And what Yannetti is saying is, yeah, we're going to use that, but that's how they put but they're going to put their own like little spin on it, in that it's not simply just that the investigation was done poorly, right? It was that, yes, it was done poorly, but even the parts that weren't done poorly, for example, the autopsy, okay, that was a thorough autopsy. That the results of that autopsy also don't point to the state's theory of the case, okay? They are, and what Judge Bev is allowing them to do is to cite. Shit, hold on. Sorry, my Siri went off. All right, and what Judge Bev is going to allow is for them to say that, for example, they didn't investigate Brian Higgins, even though there were things that occurred in the course of their investigation that they became aware of that they should have investigated Brian Higgins, and they completely did not investigate Brian Higgins. Not that, they investigated him and, they didn't they didn't reach the same conclusion, but the fact they didn't investigate him at all. So that's what it is. That's what she's saying, that he can do that.
Yeah. So Ms. Giannetti, and of course I take him at his word, tells me that they're not going to do pure third-party culprit. Okay, that's great. That makes that easier. So I will give. Sure, go ahead.
Just while we're on page 8, I just wanted to, Commonwealth does have an objection to the DQ instruction that's at the top of page 8.
Yeah, I have a check mark next to that. Ms. Giannetti, tell me about this, the absence of a recording. Are you saying that the police should have recorded Ms. Reed at her parents' house?
Right. So, obviously it's not the strongest DQ Batista argument that we would have. It did not occur at a police station, but, these days, Your Honor, it's common knowledge that everybody has access to a recorder, even on their own cell phone. It could have been done. It wasn't done. We had to rely on police memory of what my client said or didn't say when there was a possibility for a recording. So we still think we're entitled to do.
Do you think it was custodial interrogation? Or I guess I should say, do you think the evidence supports?
I think there's an argument that it was a custodial interrogation. We had police officers who, refused to sit down in the living room. They were surrounded with her. Someone who was not familiar with dealing with the police at all. So, yes, I think there's an argument that it could be considered custodial.
And I have to agree with Mr. Yannetti here, okay? Police, law enforcement, frequently record interviews, regardless of whether they are custodial interviews or not, okay? Because they do it out of an abundance of caution. They want their I's dotted, their T's crossed, and they want everything above board, okay? And the fact that these law enforcement officers didn't do that, that is problematic. And there's no reason why they couldn't have, okay? I mean, for Pete's sake, look at the Watts case, all right? They went and interviewed NK in a dadgum park. You could hear the sounds around her, the ambient sounds. There was that diesel truck running at one point that you could hear. They didn't give a rat's fat kneecap. They still recorded it. Even though the audio was not good at all, they recorded it. And why did they record it? Because it's a record. They wanted to preserve the record. And the fact that they didn't do that, none of the law enforcement officers did that in this case with anybody, not just Karen Reed. But when they went over to the Alberts house, they didn't record that at all. It's ridiculous in this day and age. There's no reason for them not to have done that. No good reason, I should say.
All right, what do you say about all this, Mr.
And
Lally?
I would also add, Your Honor,
Sure.
they did seize her vehicle at around the same time. So, that it goes to, I think, the issue of custody and my client being able to deny it.
All right. What do you say?
That's the very nature of the objection, Your Honor, is the non-custodial nature of this. So the troopers spoke to Ms. Reed at her parents' house, as they did with a number of different witnesses on that day as well, for the course of that day. They spoke to her while she was seated on the couch in her parents' living room, with the parents present. No one was restricted from eating. And it did not end in any sort of custodial situation. She was taken into custody. She wasn't arrested. Yes, they did seize her cell phone and her vehicle based on information that they had developed from the course of the day and from the statements.
Right. They seized her vehicle and her cell phone based on those quote unquote statements. So why not record those statements so they could show why they decided to do that? They should have recorded it. Stop playing with these people, Lally.
Ms. Reed herself, but I don't think that transforms that conversation or interview in her parents' living room into a custodial interrogation. The bigger issue that I have is placement, as far as there's already been within saying request of jury instructions or request for humane practice, and then following the DAG and Batista language in the defendant's request of jury instructions, there goes on to all of this other requests regarding her compromised mental state and all of these other things that, while if it were to be given by the court, should be given in the same context of humane practice. I don't think it's something that should be highlighted in two different sections. And I would submit that there is no evidence of her having a compromised mental state or anything to that effect. She exercised her judgment as far as when she was speaking with Sergeant Lieutenant and have his testimony from the stand, that initially she said she wanted to be fine with answering questions, but didn't want to get into many details. And then when the questions became centered on, more centered on details, at that point, and I know that's not evidence to the jury, but of course, well aware, she then ended the questioning at that point. So I don't think there's any evidence of her having a compromised mental state during the course of this interview, and I don't think that arises to the level of the DAG instruction. So I would ask basically that everything on page 8 prior to the oral instruction be excised.
All right. I'll take another look at this, and I'll just let you know in the morning.
And, Your Honor, with regard to the compromised mental state, we agree that that would not apply to the interview at her residence. But we believe that it applies within the humane practice context.
That is where it makes sense. So, all right.
If it's going to happen, it should happen once, not
Yeah.
I think that's fair.
Okay. Okay. All right. Prior statements, I will give some instruction on prior inconsistent, and I'll give a prior consistent statement. I will talk about the view. The absent witness instruction is withdrawn. So is the...
Not to interrupt.
That's okay. That's okay.
With regard to the view, Your Honor, we did include a fact that the rock that they saw on the view
Oh.
was not present on January 29th. We asked the court to repeat that one sentence.
Okay, so I did not see this when I took a quick look at the view. All right, I'm not going to repeat it. All right, lost or destroyed evidence you're withdrawing. Direct and indirect evidence. I'm going to try and give a shorter instruction on that. So I will, even the one I gave is too long. I'm trying to cut down the time the jury needs to hear general instructions that I think they're perfectly capable of hearing in a shorter period of time. All right, thank you. Credibility, the same. Law enforcement witness, I think I gave some instruction on that. I'll include that somewhere in it.
If I might just in reference to that.
Sure.
Only language in there that I would object to.
Okay.
Testimony of a police officer or someone else who works for a law enforcement agency.
Oh, what do you mean by that?
Or whatever.
I think that was taking into account the dispatcher, perhaps. We're not.
Yeah, I'll do police officer because they're police testimony. I'm not going to go beyond that.
I think that might be close.
Okay, thank you. I'll do the photographs, the opinion testimony, notes. I'm not saying I'm giving exactly this, but I will give, I'll cover all those topics.
If I might just as far as the photographs,
What page you on?
16.
Okay.
One suggestion there was indicates Commonwealth has introduced photographs and evidence. I would submit.
Yeah, I'm just going to say there are photographs that are in evidence. Was that the nature of your objection?
I actually think the defense has introduced more graphic.
Yeah,
photographs.
so I would just say you've seen photographs.
Fine with that.
Or there were photographs and evidence. I instructed twice anyway, maybe 3 times on it, so I'll give some version of that. Juror notes, I'll give some version. The implicit bias instruction, I'm going to give exactly what the SJC told me I should give. All right, so the Commonwealth's requests are sort of in the, you start with the law and then you get into the general instructions, Mr. Lally, so let's skip to your, it's not numbered, your supplemental instructions, use of a dangerous weapon. All right, so I'm going to give that, Ms. Giannetti. I gave a dangerous weapon instruction last year on the motor vehicle. All right, so I'll give probably what I gave last year, and this looks like it's it. What is not evidence, evaluating, I'm going to give what is not evidence, evaluating the evidence, there's some instruction. Ms. Giannetti, what do you think about the short instruction on jurors? It sort of makes sense to me after such a long trial.
Okay, here's the deal. I get why you guys don't trust her. I don't trust her either. However, this is just the skeleton of the jury instructions. Once she'll show that to them tomorrow morning, and they can still object to it. So, yeah. Now, and Sarah, I've read your comment. I don't know if I know it's me. I know it's not you. I'm just I don't quite understand your comment. Sarah says, if they, the cops, were intentionally being lackadaisical and flippant about the investigation, they knew she would not have made any bombshell statements. Even if I feel like with that, hold on a minute. Oh yeah, I can send myself. I'm over here. I'm not even looking. Right at the right spot. I feel like with that, they wouldn't know. They have no idea what a person is going to say, especially given the fact that she'd already made some, I believe they were questions, but can you guys not hear me? Am I not being here? Can y'all not hear what I'm saying? Right. And this is the issue, Rachel, right? That they can now claim she made statements. It's just not on record either way. Yes, that's the problem. That's absolutely the problem. Yeah, I had to pause it. Okay, good. Okay, I was like, yeah. All right, let's keep going. Okay. I understand. I get what you're saying, Sarah. She being Karen, so they wouldn't need to record her. And if they had more conspiracy or scapegoat mind frame, I got you.
No juror is better qualified to determine the truth of the facts in controversy or to deliberate upon a verdict than any other juror, or solely because of that, not or, solely because of that juror's occupation, education, experience, or any other characteristic. Okay. Thank you. Charts and summaries, I'll talk a little bit about chalks. And inferences, I will give some. I'll give the redacted exhibits instruction. Witness preparation for trial. Do you both want this? There was testimony on both sides. It's simply, there was testimony at trial that the attorneys, and I may say if you find, or something, preface it, witnesses when, the attorneys interviewed witnesses when preparing for and during the course of the trial. You may not draw any unfavorable inferences solely from that fact. There is nothing improper about conducting such interviews. On the contrary, the attorneys are obligated to prepare their case as thoroughly as possible and may interview witnesses. I don't know if there's a sequestration order, if this is appropriate, though, where it says during trial, during the course of the trial. I'll just say when preparing for trial.
Yeah, we're joining in the request. I don't know that we included that in our instructions, but we're joining in the Commonwealth's request for that instruction.
All right.
Yes, Rachel, she is saying chalks. I think what a chalk is a demonstrative, but I'm going to look that up because the way that I'm using context clues. So let me try to figure that out. Give me just a sec. Also, I'm going to go just a little bit longer on this. I don't know if I'll do the whole day because I just got a call from Allie and big news. So I need to call her back so we can more thoroughly investigate this big news. But that being said, I'll go just a little bit, let me see where we're at. Okay. At the end, when we get caught up to live. Okay, here we go.
Okay. Expert witnesses, electronic communication. So I'm going to go through the limiting instructions I gave. I need to just do this again here. So electronic communications, I have that on my list. The emotional impact photos, humane practice. We'll get back to consciousness of guilt in a minute. I'm also going to give the prior bad acts instruction. I did that in regard to the Aruba incident, if you want to call it that. I gave a prior bad acts instruction before that testimony came in. I also gave the instruction that I will also give on the state of mind of John O'Keefe as to his state of mind being known by the defendant and the likelihood that she would act on it. So Commonwealth versus Binns in those cases.
Oh my God, I'm smart. Look, I Googled what is a chalk in the courtroom. In the legal context, a chalk refers to a demonstrative exhibit used in court to illustrate testimony or arguments. It's essentially a tool like a drawing, model, or chart that is introduced to help jurors understand a particular point. Think of it as a visual aid rather than actual evidence that helps the court understand the facts of the case. Look how sometimes I'm smart. The Aruba incident is when they were arguing in Aruba. That's what she's talking about, crocheting Bammy.
Your Honor, we're looking to Aruba. We believe that there was really any that came in.
I thought it came in through Kaylee. I should say it did come in through Kaylee. That's when I gave the prior bad acts instruction. She testified. Okay.
I don't know that goes. Well, I don't know. I guess it could be considered a prior bad acts character testimony. The fact of the matter is, it came in through John O'Keefe's niece, and that portion of the testimony wasn't shown publicly. So, it's hard for me it's hard for me to know what was said and what was testified to make a good argument for either allowing it in or not allowing it in, or what kind of instruction there should be either way, because I don't know what the testimony was. All right, let's keep going.
All right. So did I give it any other time that there's another event that I should highlight? I don't think so. All right. I think I have to add that here. So, all right. And I will look at it and decide whether I need to add it specifically. It might be covered enough. Might be covered enough when I give the electronic communications instruction. So I will think about that. All right, those were the limiting instructions I wanted to get to. So
We would object to the part of that act being linked to the Higgins text message.
all right, I'm going to take a look at that, Mr. Alessi. All right.
Let me just
consciousness
say
of
this.
guilt.
She always refers to Mr. Yernetti as Mr. Alessi, and that's because I think Bev is sweet on Alessi.
Okay. All right. All right. So tell me where the difference is in what I gave last year from the model homicide instruction on second-degree murder and where you're saying I should not this year, Mr. Lally.
So the only,
1 second, let me just pull that up. Okay.
Your Honor, Commonwealth's request is merely not for any change or alteration in the instructions that were given, other than there are three-pronged analysis, and essentially the Commonwealth is requesting is that the jury be instructed
Speak up.
merely on third-pronged analysis. That's the only one that really applies to these factors. So
Okay.
the Commonwealth here, the first two prongs are essentially extraneous in this situation, and actually give the jury to avoid confusion.
Do you have supportive case law for me to single this out? What do you say, Mr. Yannetti?
I mean, Mr. Brennan essentially stated that in his opening statement.
Stated what?
Well, in his opening statement, he stated that he's not alleging that she intended to do him grievous bodily harm. She did not intend to kill him. And it was just the third prong. He stated that in his opening. I imagine that's what he'll likely argue in his closing. You know, I don't have a position on this. I just don't know, and I think the court's going through this analysis in your head as well, whether it's permissible or not. I just raised that as an issue, but I don't have strong feelings about it.
I could say the parties agree that the first prong and the second prong are not applicable here.
I think we're just at a position where we'll refer to the court on this.
Well, I'm not going to say you agree if there's no agreement. If you can get me a case by this afternoon,
I will endeavor to do so, Your Honor. We will. I don't have it.
I'm inclined to go with the model.
Of course you are, Judge Bev. Even though,
I'll see if there's something I can
look, even though you're not the one that's actually going to be typing any of this up, and you're certainly not going to be the one making copies like Randy at the copy. Randy, make it the copies. Copy let me ding dong. That's not happening. I don't know why it's any skin off your nose, but whatever. Fuck off.
You're
Bev.
probably better at finding it than I am, Mr. Lally, but I'll see if there's something I can find to support the position that it's just the third prong, and therefore I only have to give that instruction. I don't think I'll find anything, but let me see.
It did come in, Angel. It came in through John O'Keefe's niece, which is why we didn't hear it. She just said, Judge Bev just said that it came in through John O'Keefe's niece, and we didn't get to see that. So I'm confused now. Yeah. That's what Judge Bev said, but that's the thing. I've covered every single day of this trial. And even on the days that I knocked off early, I still watched the trial and I didn't hear it. So either it didn't come in at all or it did come in through John O'Keefe's niece.
Because I can understand why both of you don't want it. Just let the jury focus on what they need to focus on.
That's really the only reason. I understand, and I don't.
You know, I suppose I could always tell the jurors that the Supreme Judicial Court has come out with jury instructions that I must give in their entire format. And that sort of explains why I say something that doesn't apply. Maybe. Maybe I'll do that. But let me see if I can find something. If I can find something that...
All right. I've skimmed through this, and there is a point when Alessi gets up to argue. And not that I don't like Yannetti, but I like Mr. Alessi. You guys know that. He's my fave. And so let me get to that part. All right.
Know if the Wolf PowerPoint is ready to be put into evidence after the Commonwealth looks at it. Okay, so we'll take care of that. All right, Mr. Leslie, I'll hear you.
Thank you, Your Honor. If I might suggest respectfully a procedure to the court, I've spoken with the Commonwealth about what the topic is. It's obviously not new to anyone, but perhaps to expedite this matter, if I might suggest to Your Honor to avoid a more lengthier argument, it might even truncate it down to 30 seconds. If we could hear from the Commonwealth on what we have requested, and the topic specifically is entitled Defendant's Motion for Curative Instruction regarding Exhibit 88 and Introduction into Evidence of Exhibits. The exhibits is taken care of. That's no longer an issue. But I did speak with Mr. Lally, and if I could suggest that Mr. Lally could state his position as I understand it, and then I can go from there, and it may not be necessary for me to continue on.
All right. What's the Commonwealth's position?
But Your Honor, the Commonwealth's position is ultimately for the court as far as whether or not it's an appropriate instruction to give in the final charge. What the Commonwealth will submit is that the contemporaneous instruction is more than sufficient to address the issue, and that it doesn't require any sort of differing language for further instruction given to the jury during the final charge.
Okay. All right, I'll hear you, Mr.
Thank you, Your
Leslie.
Honor. May I go to the podium?
Yes.
Thank you. Your Honor, I have given, and Your Honor has provided me previously with a generous opportunity to be heard on this, but I do need to cover some points with regard to the matter. I was hoping to avoid doing this, but given what we just heard, it needs to be done respectfully. As Your Honor knows, we have submitted this motion, and as part of the motion, it really consists of two parts. The first part is the text and the basis for what we're requesting. I'll come to that in a moment. And then attached to it are is Exhibit A and Exhibit B, and those exhibits are our best effort at transcribing, because there's not an official transcript at this point of exactly what happened. Why did we put in the exhibits? We put in the exhibits because we believe it really sets forth and illuminates quite vividly what occurred. It occurred rather rapidly, but I think this allows for a much more these exhibits allow for a much more reflective analysis. So just briefly, what, as we know, happened is Attorney Brennan took Exhibit 88 encased in whatever the plexiglass material, had it set up, and we understand this now in retrospect, behind the witness stand. And then at a certain time in the cross-examination of our witness, Dr. Wolf, confronted Dr. Wolf with it as part of an accident reconstructionist cross-examination, and challenging Dr. Wolf on several aspects. And this one was particularly apt to the subject matter, not the manner of the examination, was, Dr. Wolf, you're saying this, these are your theories. However, did you consider and take into account the holes in the back of the hoodie? And that led to a series of questions and a series of answers. And I want to go right to the end, because I think going right to the end better elucidates what actually occurred and the depth of the issue and the problem here in this misconduct, which we believe was intentional. Specifically, the end is, we know, and I believe it is completely undisputed, that the holes in each and every hole in the back of the hoodie was caused by the criminalist, a witness in this case, Ms. Hartnett, who made those cuts as part of her analysis. And that was in May of 2023, long after the alleged incident of January 29, 2022. So that's sort of the end undisputed. Now let's go back to what happened in the examination, the cross-examination of Dr. Wolf. So he's confronted, and I think, we put in Exhibit A and B of it, but what is particularly striking is on page 7 of Exhibit A, and it's the colloquy that starts in the middle, which we've yellow highlighting, Attorney Brennan saying, when you were making that opinion about consistent or inconsistent, did you ever consider whether there were holes in Mr. O'Keefe's sweatshirt other than the right arm? Dr. Wolf started to answer, well, I know that there was cutting too, and I emphasize cutting, and then he was cut off by Attorney Brennan, and Attorney Brennan said, "May I approach and receive the exhibit, Your Honor?" And we note that in the context of many other statements in this regard as to what happened. So now this comes to the requested relief, and I'm going to move to the part of the argument, Your Honor, that we believe respectfully compels what we're requesting. So now I want to just state what we request. We believe what we've requested is quite modest given what happened. And our proposed curative instruction is on page 2 of our motion. It states, during the cross-examination of Dr. Wolf, Mr. Brennan asked Dr. Wolf about holes in the back of the sweatshirt, Exhibit 88, falsely insinuating that those holes were sustained on January 29, 2022 from a fall backwards. I instruct you that those holes were not present on January 29, 2022. Those holes were made by Maureen Hartnett, a criminalist at the Massachusetts State Police, I've got the acronym MSP, Crime Lab, in the course of her inspection and sampling of the clothing on May 18, 2023. Dr. Wolf correctly testified that those holes did not come from any alleged event on or about January 29, 2022. Please juxtapose that with regard to the instruction Your Honor had given, which was a sentence, so, jurors, I instruct you that those holes were made by the criminalist, Ms. Hartnett, during the course of her inspection and sampling of the sweatshirt.
Didn't I include the date you requested, the May 18th date? I thought I did.
You know, Your Honor, I think the answer is no, but because I'm doing it from memory and I don't...
This is not an official transcript, right?
Exactly, Your Honor, so I can't say it with certainty. I don't believe it was.
Okay, because that date you told me was important to you, right?
Among other factors, the date was important.
It's May 18th, right?
Yes, Your Honor.
Okay. Go ahead.
And so, Your Honor, I believe what is fair in the analysis and as objective as I can be here is I think the curative instruction has to tether to and relate to in its details the degree of what happened. This was on a very significant topic, accident reconstruction, a significant piece of evidence, the hoodie. There's been much discussion among many expert witnesses about this hoodie, what it stands for. There's been videos on it. You know, our position, the hoodie in a proper accident reconstruction would be completely unaffected by any alleged motor vehicle incident. And then to show the witness on this for the defense, it clearly left the impression to any objective observer that Dr. Wolf had somehow been incompetent, which is 180 degrees of the reality, but also that he just wasn't otherwise diligent, and the jury, therefore, should not weigh and value his opinion. This is very, very significant, and I underscore, Your Honor, we didn't cause this problem. We didn't cause any of this issue. So, to me, I do not understand why the Commonwealth would not support this. What we have written down here supports the truth. We all, I believe, should have the common goal of the jury receiving the truth. I looked at the jury. I'm no soothsayer or mind reader, but I looked at the jury and they looked confused when I looked over at them. But I think even aside from looking at a jury, what Your Honor did in good faith, I don't believe is clear enough on this key issue. And I'm not understanding why there would be any real contest over making it clear to the jury on this very important point. The defense, to my point of being measured at the time and being measured now, we could be requesting a lot more statements about what occurred. And I've been in situations in other trials where things have happened and there's been many more significant things stated. So in conclusion, Your Honor, the defense not having contributed at all to this issue, the significance of the issue, the significance of the error, it's undisputed about the error, to me, respectfully, all augurs for more clarity here. And the final point, there's two issues here. There's the fact of when these holes occurred, these cuts, and how they occurred. That's one bucket. But the second bucket, which is not in the current instruction, is our expert witness, Dr. Wolf, and the impression left upon him. And that is why we have the language in there, again, we believe quite measured, just the sentence at the end to take care of the harm to our witness with regard to what occurred. So, therefore, Your Honor, we respectfully request that this be given. so that the jury has a clear and complete and truthful understanding of not only what happened, but also to make sure that it is what's created for the jury is accuracy, hence truth can be concluded. Thank you, Your Honor.
Thank you. I do just want to point out one thing. It was not objected to at the time it came in. That's my only comment. I will consider this. I'm going to hear from Mr. Lally. I will consider this.
What is it that was not objected?
The testimony was not objected to. I didn't hear this until I think after another witness.
Your Honor, if I could, thank you for raising that. 10 seconds for that. I will, and I made this point the very time that I made the argument last time. We were not shown that Exhibit 88 in the encasement. It was behind the witness. We didn't even know that it was behind the witness. So what happened was Attorney Brennan went up, retrieved it, and immediately went to the witness with it, showed it. We couldn't even see what was happening. There was no physical nor other ability for us to object at the time. So I appreciate you giving me the opportunity to respond to that.
Yeah, Judge Bev. It was shady, shady, shady. All the shade. And not the kind of shade we over here at the ward enjoy. No, no, no. This was dirty pool. And now you're trying to say, well, it wasn't objected to at the time. Of course it wasn't objected to at the time. They couldn't see what the F he was doing. It wasn't until after it happened. Stop it, Judge Bev.
All right, Mr. Lally.
Very briefly,
Keep your voice up, please.
yes, very briefly. I'm not going to get into a belabor the point as far as the back and forth about conduct of counsel. During the heat of trial, during the heat of the extended exchange with the witness on the stand, things can happen. Mistakes can be recognized, acknowledged, and accepted as a mistake. There were numerous offers by the Commonwealth to offer a stipulation as to the truth as far as the evidence is concerned that were rejected by the defense. They wanted the curative instruction. They got it contemporaneous with when the evidence came in. There have been many, many instances of similar type conduct that didn't result in a curative instruction, and to accentuate it further in the final charge to the jury is simply improper. It was a situation that arose as far as whatever.
Lally, stop playing with these people, and I'm sorry you're over here having to do the dirty work. Look, and Judge Bev, you better rule on this correctly, because I'm going to tell you right here and right now, if you don't, I will make a video pointing out every single time that you instructed the defense to show an exhibit to the Commonwealth prior to showing it to the witness. Don't play with me, Judge Bev. You better rule on this, and you better rule on this correctly.
Misstatement was made at the time as far as whether it's from the testimony from the witness or the question from counsel was immediately remedied, was taken care of. I don't think that there's any confusion by the jury. And furthermore, as I indicated, the Commonwealth offered a stipulation at the time that this occurred, which was essentially rejected by the defense. They got the curative instruction at the time. That is all that is required. It is more than sufficient, and it doesn't need to be accentuated or addressed further in the final charge.
Okay. So I'll consider it, Mr. Alessi. Okay.
Thank you, Your Honor.
All right. Anything else?
Okay.
Two things I'd like to talk about.
I don't give a rat's fat kneecap what you want to talk about for scheduling for the jurors, because when you say the jurors, you're talking about yourself. How long am I going to be able to get out of the courtroom and go smoke a half a pack of Misties? I don't give a rat's fat kneecap about nothing you got to say. You know what you did was wrong. You shouldn't be thinking about it. It should have been ruled on. What happened in that courtroom that day with that exhibit was egregious. It was a huge error. It was a fundamental error that if they found that, if this jury, which I don't think they will, but should they find this defendant guilty, will be overturned on appeal. That's it. That's all. Especially given the fact that anytime, every time, because I even remember it happening with Mr. Alessi. I remember very distinctly you reminding him to show an exhibit to the defense or to the Commonwealth, excuse me. I remember very distinctly you telling Mr. Alessi on more than one occasion when he was going to show a witness an exhibit that he first show it to the Commonwealth. And you know why I remember it? Because every time you did it, Mr. Alessi said, "Thank you, Your Honor." Stop playing with these people, Judge Bev. Freaking ridiculous.
Scheduling. the jurors get here early, I'm going to ask if the court officers to call the jurors and ask them two things. To ask them if they can get here a little bit earlier so that we can all be in the courtroom at 8:45, ready to start. So things take a little while generally. That will assure us the closing arguments will start right at 9, maybe a few minutes earlier. The goal would be to hear arguments from both counsel and then take an early lunch break. I would ask that counsel plan on just a half an hour lunch break. I'd like, the point being, I want the jurors to start deliberating. I don't want to end the charge and send them home for the weekend. That's not fair after they've waited so long. So a short lunch, you're free to stay in the building, and court officers will help you with accommodations for that. But a short lunch, and then I'll come out and do the charge. And then at least, hopefully, there'll be some time for them to deliberate. I'm going to ask the court officers to call the jurors to see if they can stay as late as 5 o'clock or 5:30 tomorrow night. I just don't think it's fair after they've sat through so much of this trial with the various delays that we've had to not let them start deliberating.
We have no objection to that. One request we have, Judge, is during the last trial, during deliberations, the court had asked us to be within 5 minutes of the courthouse. My office is about 10 minutes away.
I'm sure we can make accommodations for that. But at some point, we may have to talk about security issues. So a lot may depend on that.
Oh my God,
Does the
security
Commonwealth have any
issues.
objection to that?
Shut
schedule?
up.
No, Your Honor, not at all.
All right, so we'll see counsel in here no later than 8:30 tomorrow morning? Sure. We'll counsel here at 8:30. All right, thank you.
All right, that's it. That's all, folks. So I'm so glad that, yeah, she's going to have the jury stay until 5:30. Meanwhile, yeah, you know what that means, Judge Bev. No karaoke. All right. Anyway, thank you guys. That's it. That's all. Tomorrow we're going to be here 9 o'clock. Well, they want everybody here ready and to start at 8:45. All right. So that means 7:45 for us. All right. Well, I will be here. We will go through all of it. I'm so excited. Allie and I have some huge news for you guys. So make sure, will one of the mods please use the exclamation point, lowercase a, LLIE, and drop Alex Erickson's chat. You want to make sure that you are subscribed to her channel. Make sure that you have all notifications set to all. You want all the notifications. Okay. If there is a verdict in Lori, I will come on. Yes, Tess, let me go ahead and thank you, Neat Noodle. Let me go ahead and schedule that for the verdict. I'll do it. Tess. So I am super excited. You guys are going to love it. I already love it. And I can't wait. I do think we're going to get a verdict today with Vallow. So I will schedule it. I'm not even gonna take a nap today, which I am entitled to, but I am not doing it. So thank you guys all for being here. I appreciate it so very much. If you haven't done so, please give me a thumbs up or a thumbs down, whichever you prefer on the stream. I'm going to go and schedule the verdict watch for Lori right now. Just turn the notification on. It doesn't matter the notification will still go out regardless. As long as I don't delete the stream, it'll go out when I go live. Just make sure you turn the notification on. If you try to do it at the time of the live, like say I scheduled the live for 12:30 Central Time, which should be 1:30 Eastern. If you get in the live at 12:30 and it says waiting for the ward, I don't think you can turn the notification on at that point. So you're going to want to pay attention to that. All right. Anyway, no, it is not about Gypsy Rose, Sissy's mom. There you go. That's your hint. That's it. That's all. I will talk to you guys later. Have a great rest of your afternoon. I'll see you for Lori's verdict. Hopefully soon. All right. Bye, you guys.